Welcome back. This is the beginning of the second series of videos discussing the Google Book Search litigation. In the first series, I outlined some of the basic copyright issues involved in this case and explained why Google may well have won the fair use argument if it had not reached a settlement with the plaintiff authors and publishers. In this series, I plan to review the actual content of the settlement agreement in some detail. Once again, a full set of the slides accompanying this presentation is available at my website, and an article complementing this presentation will be posted very soon on ssrn.com. On October 28, 2008, Google announced that it had reached a settlement of a highly publicized class action lawsuit brought against it by the Authors Guild and another equally important lawsuit brought by the American Association of Publishers. The settlement agreement is a complicated document consisting of 141 pages, 160 definitions, 17 separate articles, which break down into about 116 separate clauses, and this does not include the substantial provisions contained within the 15 attachments to the agreement. This preliminary summary of the operative terms of the settlement is no substitute for individually tailored legal advice. This presentation does not constitute legal advice, nor does it establish any attorney-client relationship. The effect of the settlement is sweeping. On its own terms, the settlement embraces all books currently protected by copyright law which were registered with the US Copyright Office and published before January 5, 2009. The settlement expressly excludes works such as periodicals, personal papers, sheet music, and songbooks. It also excludes government works and other works in the public domain. The settlement also covers independently copyrighted works within books, which are defined as inserts. Inserts include forewords, afterwords, prologues, epilogues, essays, poems, quotations, letters, song lyrics, or excerpts from other books, periodicals, or other works. They also include children's book illustrations, although other types of illustrations are not covered within the definition of inserts. The settlement gives Google the right to continue to operate its book search program along its current lines, but with some important modifications. Prior to the settlement, Google allowed minimal access to books except where the work was in the public domain or was subject to a specific agreement with one of Google's publishing partners. This resulted in three basic tiers of access: a snippet view by default, various levels of extended preview determined by agreement with the publisher, and full access to public domain works. The same basic tiers of access remain under the settlement with the addition of a no display option. In addition, the settlement envisages new services, including a consumer purchase model, institutional subscriptions, and various other new revenue opportunities that remain subject to negotiation between Google and the rights holders. The settlement gives rights holders substantial individual flexibility to determine their own preferred level of access to their works, as well as the effective ability to opt out of the Google Book Search engine altogether. On the other hand, the settlement sets many of the default provisions very favorably for Google and thus effectively gives it a broad license from the otherwise silent owners of orphan works. What are these orphan works I just mentioned? The US Copyright Office characterizes a work as orphaned where the owner of a copyrighted work cannot be identified and located by someone who wishes to make use of the work in a manner which requires permission of the copyright owner. Orphan works is really not a very good label. Estranged works might be a better label, but this is the one we're stuck with. The important thing to understand about orphan works is that they're works which are not actively managed, and they're works for which the costs of identifying and tracking down the copyright owner are going to be very high in relation to the actual value of the work. One of the most important features of the settlement is the creation of the registry. The registry acts as both an information intermediary and as a collection society. The registry will own and maintain a rights information database linking books to their appropriate authors and publishers. It will also locate and identify rights holders and thus reduce the number of orphaned works over time. The registry will also play an important role in determining how books should be classified, and it will help authors communicate their preferences to Google. The registry will receive money on behalf of authors and distribute money to authors pursuant to the settlement agreement. The registry will also play a key role in negotiating prices for the new revenue opportunities. The most remarkable feature of this new registry is in relation to orphan works. The settlement agreement suggests that the registry will have the power to negotiate licenses of orphan works to third parties. This is one of the most controversial aspects of the settlement agreement. Critics have complained that whereas a fair use ruling would have substantially mitigated the orphan works problem for all potential entrants into the field of book search, the settlement agreement only solves the problem for Google and thus effectively creates an orphan works monopoly. However, this issue is far from black and white. For example, it's unclear exactly what the economic significance of this alleged orphan works monopoly would be. Moreover, one of the consequences of the settlement is that there should be an incentive for a number of copyright owners to reclaim active ownership of their works, thus effectively de-orphaning them. Most importantly, the creation of the registry goes a long way towards solving the orphan works problem for Google's competitors down the road. Would-be competitors now have a single institution with whom they too can negotiate licenses with respect to orphan works. Although it seems clear from the agreement that the parties are working under the assumption that the registry will have the authority to license orphan works to third parties, the agreement does not actually contain an express license from the class members to the registry. This apparent oversight should be remedied. The immediate cost of the settlement for Google is well over $100 million. Google will transfer a minimum settlement fund of $45 million to the registry to be distributed among the class members whose books have been digitized prior to the opt-out deadline. Under the plan of allocation, class members will receive at least $60 per book and $15 per insight. Google will also pay $34.5 million to fund the launch and initial operations of the registry and $30 million to pay the plaintiff's attorney's fees and costs. Thus, Google will pay at least $109.5 million under the settlement, regardless of the revenue it generates from its book-related products and services authorized under the agreement. On first impressions, Google has agreed to a 30-70 revenue split with the rights holders for advertising and purchase revenues attributable to works covered by the agreement. However, these revenue streams are defined with a built-in 10% deduction for Google's operating costs. This 10% deduction can itself be offset pursuant to the unclaimed funds provision, which means that in theory at least, active authors can profit from the exploitation of orphan works and misclassified public domain works. It is important to note that the revenue split does not apply to works outside the scope of the settlement, such as public domain works, nor does it apply to initial search result pages which feature more than one work. The material we've covered so far is only the beginning of this analysis. In the next video, I will begin to analyze the rights and permissions set out by the agreement, in particular try and understand what the settlement allows Google to do with all these books it's been digitizing.